We're joined by our friend Julie Kelly. Please check out her Substack, Declassified, with Julie Kelly. And Julie, appreciate you being with us. Let's dive right into it. Fisher v. United States. Supreme Court heard oral arguments today. Before we get into where you think the judges are going, can you just give us background as to what's at issue here and why it's such a big deal, not just for Trump, but for a lot of J6 defendants?
Right. So this relates to the government's use, DOJ's use of 1512C2, obstruction of an official proceeding statute. This was passed in the aftermath of the Enron Arthur Anderson scandal. It has to do with evidence tampering or document shredding, as we saw in that case. What the DOJ has done for the first time ever is weaponize that statute to criminalize political dissent and charge now roughly 350 January 6 protesters with this felony offense, punishable by up to 20 years in prison. It finally, 3 years later, has made it to the Supreme Court and oral arguments. Joseph Fisher was one of these defendants charged. The district court judge, Carl Nichols, is the only one who dismissed this count against him, and the DOJ appealed that, which is how now we got to the Supreme Court oral arguments today.
Okay, Julie, I listened to part of this. I saw the questions. I wasn't able to listen to every minute like you were because you were inside of this courtroom. But I have been in the Supreme Court before and been able to forecast by watching and listening and seeing body language and everything else what I thought was likely. Based on what I saw, I see this as a 6-3 at worst win that would strike down the use of these statutes. Do you agree or disagree with that? How would you assess your read of the justices' questions and where their opinions may lie as a result?
So just to clarify, I wasn't in the courtroom today.
Oh, my bad.
No, that's okay. Fortunately, you can cover all of these proceedings on the Supreme Court website and also C-SPAN, and it's just easier to do it that way. I will tell you, I was a little worried, I think, and disappointed at first with Fisher's attorney's presentation. I didn't think it was as strong as it needed to be, and the questions were tough as to the two different parts of the statute that are now in question. But I sort of agree. It could be 6-3. It might be 5-4. Amy Coney Barrett, again, seemed a little bit unclear as to her position, which might be fine. But look, the idea that you can take an entire code of the U.S. Criminal Code, 1512, which only has to do with tampering with evidence or witnesses in judicial proceedings, and clip out this subsection and set this aside from everything else to make it sound that official proceeding, which is used throughout 1512, meaning a judicial proceeding, not a function of Congress, to carve that out and not only now take the novel approach of using it to congressional proceedings, but of course only apply it to those people involved in the events of January 6th, which, as you guys know, this became quite clear during the discussion today.
Actually, Julie, can we jump in here real quick? Because sure. We wanted to play for everyone to hear Supreme Court Justice Gorsuch. This is cut 28, dealing with exactly what you're talking about, which is, so only in this congressional instance is obstruction a problem. Play it.
Would a sit-in that disrupts a trial or access to a federal courthouse qualify? Would a heckler in today's audience qualify, or at the State of the Union address? Would pulling a fire alarm before a vote qualify for 20 years in federal prison?
The actus reus does require obstruction, which we understand to be a meaningful interference. We'd also have to be able to prove that they acted corruptly, and this sets a stringent mens rea. It's not even just the mere intent to obstruct. We have to show that also, but we have to show that they had corrupt intent in acting in that way.
So mostly peaceful protests that actually obstructs and impedes an official proceeding for an indefinite period would not be covered?
Not necessarily. We would just have to have the evidence of intent, and that's a high bar.
They intend to do it, all right.
Yeah, I just think he nuked their whole argument here. I don't know how they get around this. There's absolutely no legal basis to. She's saying, corrupt mens rea or something. Yeah, they're obstructing. They want to obstruct, and they're obstructing. Well, really, it seems to me, Julie, what she's saying is, well, if, it's climate change protesters, we like them, so we're not going to throw them in prison for 20 years.
That's exactly what she was saying, and I'll take this a step further. I just emailed last week the spokeswoman for the D.C. U.S. Attorney's Office, the federal prosecutor handling now 1,400 plus J6 cases, and I asked her, have any of the pro-Palestinian, anti-Israel demonstrators who have done the same sort of conduct over the past 6 months, especially in Washington, D.C., and unlawfully entering Capitol buildings and disrupting Senate hearings, have they faced any federal charges, including obstruction of an official proceeding? And she told me no, that all of these cases are being handled by the local D.C. prosecutor, which means they will be local offenses. So I was a little surprised that Elizabeth Freligor was not better prepared to answer the selective prosecution angle of 1512c2 and the potential slippery slope, which the justices seemed concerned about. That if you carve this out and turn this into a felony, punishable by 20 years up to prison for someone screaming during, a proceeding of the Supreme Court or a Senate confirmation hearing or anything we've seen, especially the past 6 months. But she's saying, oh, no, that won't apply. And they're asking, well, why not? Well, I just don't think it will. That's not going to satisfy the inquiring minds of the justices.
Julie, as always, you're doing an incredible job covering this. And I have to give you credit. Years ago, you started raising this as a potential issue. And I think a lot of people shot you down with, oh, there's never going to be any impact on this. And now it seems likely that the Supreme Court is going to strike down, I think, prosecutions under this statute. If we are correct about that, and in June, the Supreme Court issues an opinion, you said maybe 5-4, 6-3, I think you would agree that it's likely that they are going to strike it down. What is the impact then? Where do we go from there?
Well, thank you for saying that. That's why today was so gratifying, because I have been covering this for over 3 years and hearing from, more importantly, the defendants and their families and what this obstruction felony charge has destroyed their lives and families and bankrupted them. So what it will mean for them, they will get to go back and say that the Supreme Court has reversed the DOJ, Matthew Graves, the D.C. U.S. Attorney, and 17 judges on the D.C. District and Circuit Court who upheld this count even when they understood how vague it was, how broad it was, how selectively it has been applied, and the slippery slope that it creates. These defendants now will get long-awaited exoneration, and hopefully they will have this charge reversed. They will be released from prison. They'll have the charge dropped. They won't face prison time. And this will represent a huge black eye to the D.C. federal court system and the U.S. Attorney's Office in D.C. and DOJ for abusing this law to, yes, create a set of political prisoners who only have been subjected to this felony when no one else has. And as Elizabeth Freligor said today, no one else will be, just J6ers.
Julie, how does it apply to Trump? So we know that they're trying to still rush through this case. I believe this would knock, in theory, 2 of the 4 charges that Jack Smith is trying to bring against Trump out of the contemplation, right? What would that mean as you see it for that trial in the event that we're right and this ruling comes down? Because to make it like kind of Trump specific, I believe I'm correct that 2 of the 4 charges against Trump for January 6th related charges in D.C. are these aspects that are being examined.
You're exactly right. So this has great jeopardy to Jack Smith's criminal indictment in Washington against Donald Trump, which of course is now indefinitely postponed until the Supreme Court renders an opinion on presidential immunity. Those hearings are next Thursday, by the way, for people who want to tune in. But this does jeopardize his indictment, and it should. If the Supreme Court comes back and they need to very clearly say any congressional proceeding, including the events of January 6th, does not apply to the meaning of official proceeding in the entirety of 1512, including 1512 C1 and C2. And this has to do with destruction of evidence, evidence impairment, document shredding, etc. So if they come back and they say that January 6th is not an official proceeding as it relates to 1512, then I don't see how Jack Smith continues to keep those 2 counts in his 4-count indictment. There are other ways the Supreme Court could hedge and protect within Jack Smith's indictment. You heard a little bit of Amy Coney Barrett, which made me nervous, sort of reiterating Jack Smith's talking points that the electoral certificates represent a document or record in an official proceeding. So hopefully the court will come back with a strong resolution to that as well. But, this will be also, I should have added special counsel Jack Smith and his team, a black eye to him as well for bringing such a vague, untested statute in a presidential, unprecedented criminal indictment against Donald Trump.
Julie Kelly, Declassified on Substack. Please subscribe to it. Julie, we'll be talking to you a lot between now and the election. Thanks for being here.
Thanks, guys. Really appreciate it.
She really is doing fabulous work, Buck. If anybody's out there and wants to keep their eyes on all of these cases, I don't know of anybody that's working harder and giving more interesting takes than Julie right now. You can take advantage of the MyPillow $25 extravaganza sale going on right now. Great deals, perfect way to experience so many of their fantastic products. You'll find items like their MyPillows made with the all-new Giza fabric, just $25 each, or their 2-pack multi-use MyPillows for just $25, or their 6-pack towel sets for the same price, just $25. Maybe you want to try the sandals with the summer coming again, just $25. Dozens of items at the price point. Use our names, Clay and Buck, as the promo code. It's the MyPillow extravaganza sale. Just go to MyPillow.com, click on the radio listener special square. For these $25 deals, you'll get free shipping on orders over $75. Use the promo code Clay and Buck to access the sale. That's MyPillow.com, promo code Clay and Buck.